After the judgment 2 days ago, Peter Obi has expressly stated that he was going to move to the Supreme Court. So also Atiku has, also said the same thing. But right now, the reports reaching us is that Court of Appeal intentionally frustrating our move to approach Supreme Court from Atiku camp alleges. Before we go into the details of today's news, if you haven't subscribed to this channel, please do well to subscribe. Turn on the post notification bell so that you can be the first person to get notified whenever we upload a new video. Help us grow this channel by giving this video a massive thumbs up so that it gets recommended to other YouTube viewers all around the world as well. Lastly, please leave your opinions in the comment section below. Without further ado, let's delve right into the details of today's news. Court of Appeal intentionally frustrating our move to approach Supreme Court, Atiku Abubakar camp alleges. The camp of the 2023 presidential candidate of the People's Democratic Party, PDP, Atiku Abubakar, has accused the Court of Appeal of intentionally frustrating their plan to approach the Supreme Court. The Special Assistant to Atiku Abubakar on Public Communications, Frank Shaibu, in a statement on Friday, said the Court of Appeal is yet to provide their lawyers with the certified true copies of their judgments 3 days after the verdict was given, knowing fully well that they have just 14 days to file their appeal to the Supreme Court on the judgment. He accused the appellant court of intentionally wasting the time needed by their lawyers to digest the judgment before approaching the Supreme Court. NEWSROOM Nigeria records the tribunal had on Wednesday, 6 September, dismissed all the petitions filed against the victory of President Bola Tinubu. However, Atiku and the PDP rejected the result and vowed to appeal the tribunal verdict at the Supreme Court. Shaibu on Friday alleged, however, that by not making the certified true copies of their judgments available to Atiku and PDP lawyers, the appeal court is only trying to undermine their quest for justice. According to him, by not making available to Atiku Abubakar, presidential candidate of the People's Democratic Party, the certified true copies of the judgment of Wednesday for its filings at the Supreme Court, the Presidential Election Petitions Court is undermining Atiku's and Nigerians' quest for justice. Frank Shaibu reminded the Presidential Election Petitions Court that it had made heavy weather at the delivery of its judgment on Wednesday, that parties need to adhere strictly to the time schedule set by the court. He noted that the Presidential Election Petitions Court is not oblivious that 3 previous days of the 14-day limit for parties to file their processes at the highest court have been wasted by the appeal court. We wish to remind the Presidential Election Petitions Court that it struck out the testimonies of some of the witnesses of Atiku during the litigation at the courts of first instance because their statements on oath were filed out of time, and now, from all intents and purposes, the same court wants to have Atiku and PDP's appeal to the Supreme Court disqualified by reason of time deadline. Does the Presidential Election Petitions Court not understand that the lawyers representing Atiku and PDP need to digest the judgment as contained in the CTC, which represents the authentic pronouncement made in court on Wednesday, in order to formulate its case for filing? Frank Shaibu queried. Why the tribunal rushed to release a judgment still undergoing panel beating instead of waiting to properly finish its work. Atiku's aide noted that it is anti-democratic of a tribunal to make their camp lose 3 days that would never be recovered. In his view, there can be no justification for the Presidential Election Petitions Court not making available the CTC of its so-called judgment for Atiku to continue with his quest on behalf of over 200 million Nigerians for substantial justice, as opposed to the judgment rendered by the Presidential Election Petitions Court. It is curious that the same Presidential Election Petitions Court that claimed that the judgment was ready as at the time it was delivered on Wednesday is still grappling with typos and errors according to available information. Why did the Presidential Election Petitions Court not wait till next week to deliver the judgment, as it would still have met the legal deadline, instead of rushing to render a judgment which test is still undergoing panel beating? It is anti-democratic of a court to still, already at the last count, 3 previous days out of a 14-day time limit for Atiku to file his processes at the Supreme Court. The lost time would never be recovered, he said. You all, let me have your thoughts in the comment section. What do you all think about this? I feel that, seeing the time wasting and all of this, 3 days out of 14 days has been lost. The lawyers of Atiku and Peter Obi would have been preparing for their case, that they want to take to the Supreme Court by now. But the tribunal judges who should have been ready before time, and made sure that they make these CTC copies available to each of these political parties, they did not do that. I feel at this point it's very fair to give back the time that these, political parties have lost, to give it back to them. Instead of minusing 2 days now from the 14 days, they should just, agree to give them back the time that have been lost, since the judgment, some of the witnesses were even struck out because they were not presented on time. So I feel it is fair to give them back the lost time, instead of permanently just removing the 2 days or 3 days that it's going to take them to make these CTC copies available to the parties. You all, let me have your thoughts in the comment section. What do you all think about all of this? Subscribe if you haven't. Share this video with your friends and family. I will see you all in my next video. Bye for now.